welcome back to Study Time Anytime YouTube channel. And I know you're all of you are preparing well, and the preparations are going well for your law exams as well as for the lawyers who are preparing for their NCA exam. So, continuing the second part of Constitution, we are going to start the third chapter of the Constitution, that is the executive power. Article 9, the heading of it is Declaration of Executive Power in the Queen. So, the article as it mentions, I'm zooming it, the article mentions the executive government and the authority of and over Canada is hereby declared to continue and be vested in the Queen. So the executive head is Queen, and the executive government and authority of and over Canada is with and only with Queen, and is continued. Two things. First, it is continued and is vested. That earlier she was having the authority, and it is continued, and it is again vested in the Queen. Next article, article number 10, application of the provisions referring to Governor General. So the provisions of this act referring to Governor General extend and apply to the Governor General for the time being of Canada, or other chief executive officer or administrator for the time being carrying on the government of Canada on behalf and in the name of Queen, by whatever title he is designated. So important here is carrying on the government of Canada on behalf and in the name of Queen. This is important. Title is not important, so it is already mentioned that by whatever title he is designated. So this is article 10. Next article is number 11, the Constitution of Privy Council for Canada. We have earlier learned in our previous video that what is the role of Privy Council with the Queen, and now it mentions about the Constitution of Privy Council for Canada. There shall be a council to aid and advise the government of Canada. So this council is having the purpose to aid and advise the government of Canada, to be styled the Queen's Privy Council for Canada. Its style is like the Queen's Privy Council, and the persons who are the members of that council shall be from time to time chosen and summoned by the Governor General. So the members, the persons of this Privy Councils are chosen and summoned by the Governor General. So the power is vested with the Governor General, and sworn in as Privy Councillors and members thereof may be from time to time and removed by Governor General. So appointment is by Governor General, removal is by Governor General, and the summoning is also by the Governor General. So all the powers are vested with Governor Generals in regard to appointment, removal, and summoning of, and even if they are sworn, they have to be sworn to become the Privy Councillors. So all the powers are vested in Governor, vested with the Governor General of Canada. Further, next article is article number 12, all powers under acts to be exercised by Governor General with advice of Privy Council or alone. So it is mentioning that the powers under the acts are to be exercised by the Governor General with advice or alone. Now we'll see the details. What it mentions that all the powers, authorities and functions which under any act of the Parliament of Great Britain or the Parliament of United Kingdom of Great Britain and Ireland or legislature of Upper Canada, Lower Canada, Canada, Nova Scotia or New Brunswick are at the Union vested in or exercisable by the respective governors or lieutenant governors of those provinces. So what's it saying here, that all the powers, authorities, functions under the Act of Parliament of Great Britain or of the Parliament of UK or of the Legislature of Upper Canada, Lower Canada, Canada, Nova Scotia, Brunswick are at the Union vested in or exercisable by respective governors or lieutenant governors of those provinces. So these powers are with governors or lieutenant governors of the concerned province, and with the advice and consent or respective of the respective executive council thereof. Advice and consent of the executive council or in conjunction with those councils or with any number of members thereof or by those governors or lieutenant governors individually shall, as far as the same continue in existence and capable of being exercised after the Union in relation to Government of Canada, be vested in and exercisable by the Governor General. So now, earlier all the powers and authorities was governors, the lieutenant governors of the provinces are vested with the powers, authorities and functions by the legislature, by the parliament, and they with those governors of provinces with the advice or consent of the executive council thereof or in their conjunction of those councils or with any number of members of that council or by those governors or lieutenant governors individually. What they do, they as they continue as far as they are in exercise or are capable in relation to the Government of Canada, these are all vested and exercisable by the Governor General with the advice and consent or in conjunction with the Queen's Privy Council for Canada or any members thereof by the Governor General individually as the case requires, subject nevertheless, except with the respect to such as exist under Acts of Parliament of Great Britain or Parliament of UK, to be abolished or altered by the Parliament of Canada. So the entire scenario simply means that the authorities, the functions at the Union are vested by the governors individually or with the executive council, and the governors after the Union, all the powers after the Union in relation to Government of Canada, they are vested with Governor General, and it also works with the advice or in conjunction with the Queen's Privy Council or individually also. So, but the case requires general work individually or with the advice of counsel. It depends upon the cases as the conditions required, and subject nevertheless it can be abolished or altered by the Parliament of Canada except the acts of Parliament of Great Britain and Parliament of UK. So these cannot be altered or abolished. Next, here is Article 13. Applications of provisions referring to Governor General in Council. The provisions of this Act referring to Governor General in Council shall be construed as referring to Governor General acting by and with the advice of Queen's Privy Council for Canada. So wherever the word Governor General in Council is referred, it means the Governor General acting by and with the advice of Queen's Privy Council. Next, Article 14, power to Her Majesty to authorize Governor General to appoint deputies. So it shall be lawful for the Queen, if Her Majesty thinks fit, to authorize the Governor General from time to time to appoint any person. There is no qualification mentioned here. They are just mentioning to appoint any person or any persons jointly. So more than one person, 2, 3, 4 can jointly be the Deputy Governor General or severally to be his deputy or deputies within any part or parts of Canada, and in that capacity to exercise during the pleasure of Governor General. So no time mentioned, no limitation there. It was just upon the pleasure of the Governor General. Such of the powers, authorities and functions of Governor General as Governor General deems it necessary or expedient to assign to them. So their powers and authorities will also be dependent on the satisfaction of Governor General. So subject to any limitations or directions expressed or given by Queen, but the appointment, so these all powers or authorities are subject to any limitation that might be expressed or given by the Queen. But the appointment of such a deputy or deputies shall not affect the exercise of Governor General himself. So if there is the powers of Governor General will not be reduced or changed or altered, even there exists or they appointed more deputies or Deputy Governor General are appointed. Next, here is Article 15, Command. Designation of Commander-in-Chief. Command of armed forces to continue to be vested in the Queen. So the Command-in-Chief of the land and naval, militia, and of all naval and military forces of and in Canada is hereby declared to continue to be vested in the Queen. So two types of military mentioned, land and naval, but air is not mentioned. Air Force not mentioned. So the head of the military, the Commander-in-Chief, is Queen. And last, Article 16, a seat of Government of Canada. Until the Queen otherwise directs, the seat of Government of Canada shall be Ottawa. So the capital of the Canada is Ottawa, the national capital as mentioned here. You can see national capital is Ottawa, and the Queen has the power to change the national capital. So this is the end of the chapter number 3. Hope you like it. If you like it, please like the video, comment thanks if you find it good, and subscribe the channel for more legal updates. Thank you very much for discussion.